Good afternoon, esteemed colleagues, faculty members, and participants. I, Dr. Nidhi Singh Arora, Assistant Professor, Faculty of Law, Integral University, am delighted to welcome you all to this crucial session of our one-month faculty development program on integration of intellectual property rights, principles into teaching, research, and professional activities. Today's discussion promises to be both enlightening and essential as we explore the profound impact of IPR on our academic and professional landscapes. It is my distinct honor to introduce our esteemed speaker for this session, Professor Dr. Jijimon V.S. Sir is currently serving as Director of Amity Law School at Amity University, Mumbai. With a rich and diverse academic professional background, Sir's career is marked by his dedication to legal education and his significant contribution in the field of before joining Maharashtra National Law University, Mumbai, appointed by Government of India. In this role, he served as a director of Center for Research in Intellectual Property and was also the Associate Dean Academics. His tenure saw him actively advising the government on intellectual property matters, contributing to crucial policy changes aimed at fostering innovation and protection. Dr. Jijimon also designed and executed several certificate courses on IPR, highlighting his commitment to spreading knowledge and fostering expertise in this domain. Sir's academic journey began with BA LLB from University of Kerala, followed by an LLM from Hidayatullah National Law University, Raipur, and a PhD in law from Chanakya National Law University, Patna. His nearly 2 decades of experience in teaching, research, and practice have seen him holding several key positions, including founder head of the department at Dharmshas National Law University, Jabalpur, and Mar Gregorius College of Law. He has also taught at Rajiv Gandhi National Law University, Patiala, School of Law at Christ University, Bangalore, and National Law School of India, University, Bangalore. Additionally, he served as a registrar of the Bar Council of Kerala, M.K. Nambiar Academy for Continuing Legal Education in Kochi. Sir's contribution to legal education are significant. He was also the chair coordinator of Padma Bhushan Professor N.R. Madhava Menon Chair on Legal Education and an expert member of Legal Education Committee of the University Grants Commission, Committee on Transforming Legal Education. From 2012 to 2017, he closely worked with Padma Bhushan Professor N.R. Madhava Menon, organizing professional development training programs for lawyers and law teachers across India under continuing legal education. As a prolific researcher, Dr. Jijimon's interest spans several areas of law, including intellectual property law, alternative dispute
Nidhi,
resolution.
ma'am, can I interrupt you in between? I
Yes,
just
sir.
wanted to cut you down and then going on reading my CV. Uh,
Yes, sir.
Probably I should go on to this session because this is more important than the CV of a speaker.
So that's your humility and modesty. I really appreciate that, sir, and thank you for that. Okay, so sir, I'll just directly move you on to the session
Yes,
as
ma'am.
per your
Yes.
convenience. So without further ado, I would extremely honored and extremely delighted to invite you, sir, and to take the stage and enlighten us on this very pertinent topic. And please, all of you, join me welcoming, sir. So on to you, sir. Thank you.
Thank you, Dr. Nidhi, ma'am. Thank you for inviting me for the session. The session is on the basics of intellectual property rights. Mm, to speak about the basics of intellectual property rights for 2 hours is a very difficult task because um, basics are very little with regard to intellectual property rights are concerned, but I can go on speak about the IPR for many hours. So I thought I will try to cover up the issues that I mean not issues major connections with regard to intellectual properties are there, and something on what is the what you call as the patent, trademark, or copyright, or GI, or patent right, whatever it is connected with the intellectual property. I just would give you a highlight on what all are connected to what is called as the IPRs. Now, because I hope the participants for the program are both students and academic staff who have some knowledge of IP. So, if not, please stop me anytime to clarify on if I say something which is not known to you, or which is something which is very new to you. So you can always interrupt me in between so that I can clarify those and then go further in with regard to my presentations are concerned. Now, when you speak about the issues, or when you speak about what is this intellectual property rights are concerned, now there are three things over there. There are what first thing is called as the intellectual, the second thing is called as the property, and third is called as the rights. So that means it is always connected with something called as the rights associated with somebody, some people who have developed it according to their own capacity, based on their intellectual preparations, or based on their research, whatever they have done. So this is something wherein comes in where a person's intangible developed rights are being protected through a legislation through various legislation called as the Patent Act, copyright, or whatever the nomenclatures we use in the IP Act is concerned. Now, to be starting with the basic concept of property is concerned, the term property is derived from a Latin word which has equivalent to a French word which means a thing owned. The terminology is only for the purpose of you to understand that this is something which denotes to what we always have as a physical property, or what also uh, we also have as the property that is connected, uh, or which is protected under any of the law that has been present in the countries is concerned. And you know that I mean, to those who are those who do not know that we had something called as a right to property in the constitution before, wherein making that everybody had the right to protect his own property uh, from any third party's interference, any third party's misuse, any third party's uh, destroying it. So this is a right which is protected as a part of every human being, and we also call it as a fundamental right to protect. So we also call it as a human rights, as a part of our human rights uh, documentations that we have world over. So the property that we are discussing today is something which is very connected, and which is very seemingly related to what physical property does we have. So intellectual property is also one of such kind of property rights which has close association with law, and the law protects these rights. Now there are so many terminologies that we have with regard to the intellectual property rights. We call it as corporal property, or we call it as an incorporeal property. See, these are the types of property that normally we deal with regard to these are terms that we normally deal with regard to the legal aspects of the property is concerned. Corporal property refers to a tangible or a physical property that can be touched, seen, or like a land property that we have. And it also it can also be in various two categories, like is mobile property or removable property. So if I give an example of a mobile property, like the vehicles, the furniture, the personal belongings which we can remove from the place to another place. Corporal immovable property refers to the fixed to one place that like land, buildings, or in the form of a real estate are concerned. So the ownership and transfer of corporal property are usually governed by the property laws are concerned, which outlines the rights, responsibility, and other associated rights with regard to this property is concerned, whether it is a mobile property or an immovable property. So we have protection rights already been given us transfer property act, that is which protects with regard to the mobile and immovable properties are concerned. Now, with regard to the incorporeal property is a concern, it is we normally call it as an intangible assets, or rights that do not have any physical form, but still hold a value that can be transferred to another person, like uh, the properties which we called as securities, which in the forms of bonds, which in form of stocks, even though we own it, but we do not have anything also physical format. You may say that there's a paper bond is available. No, not in that particular format. As the other corporate property level, it is not in that format. But these are certain rights we transfer. We as a owner have a right to transfer also. So these are called as incorporeal rights, and under these incorporeal rights is what is called as, we have something called as the intellectual property. And intellectual property, it includes the various forms of intellectual property, maybe based on the creation, based on the invention, based on the entities, etc. are concerned. I've used certain two terminologies in the slides, which is called as uh, in jura in re linea, which means right over the property of another. Now, these rights refers to legal entitlement that a person holds over the property owned by someone else. In essence, that it is something. The term means that it's a form of limited rights that do not involve full ownership, but allows the holder to use certain part of it. Now, intellectual property comes within one of that purview wherein these rights are being used and being transferred to another person. These rights are being used by the another person. So these rights have been used by the other person. So intellectual property is totally basically decided upon industrial property or literary property. Both things are covered within the purview of uh, the IPR, that is we are going to discuss today. Now, when it comes to intellectual property rights are concerns, intellectual property rights provides a legal mechanism for protection of the creation of human mind. Now, it means that the creator or the inventors are given an exclusive right over the intellectual creation that the author or the creator has created. Now, the reason for such kind of protection, or as I said, it's an intangible right. That means a person who is using his intellectual capacity to produce or to create something should be given that benefit of it as a property that he has created. So IP specifically deals with such kinds of right. Intellectual property specifically deals with such kind of right. And the purpose why this particular protection or rights have been given is the reason for fun is the fostering innovation and creativity, protection of investment, then the knowledge that a particular person, I mean, he has invested a lot of time in over there. He has invested his, there may be a sponsor, or he might have invested his own money over there, and he might have had some uh, co person who has already worked along with him. So all these people's the invention that they create should be having a right over which they can actually monetize it in the for the future and for the development of them. Maintenance of cultural and technological diversity. Now we also look into the concept of geographical indications which are associated with a particular category or particular places are concerned. So in those, the cultural and cultural rights also need to be protected. But that's the reason why we also have something called as the geographic indications, or the rights associated with this. Now then, for promotion of competition and internationals, when when there is a competition between two or more companies are involved, they go into further more development or best technological advancements comes in over there. So that is also one of the reason why there is a need to protect the intellectual property. Now, if we do not have advanced technology being used for the purpose of technological developments, it is very required. The benefits of always the development in the field of science and technology should reach the consumer. So market value for these products is also one of the requirement. And that's the reason why protection are being given for the intellectual properties, as well as economic growth and job creation for more people, because the development of the development a new innovation, new technology, new ideas, when it comes in over, it creates more opportunity for the marketization of it. The products are sold, I mean, the technology may be utilized by the foreign countries for development. uh, if I give a simple example, we were first running our vehicles on a different mode of fuel. Now we have reached up to a technology wherein the EV, the electronic version of vehicles are coming into road for the purpose of that. That has also created lot many opportunities. The economic growth has done. The job creation has been increased. So all these are the reasons why, or one of the reasons why, which the intellectual rights, intellectual property rights, need to be protected. Now, and I was specifically mentioning about the IP. The IP is an exclusive right, uh, and if you analyze the IP as a right, we call this IP as an intangible right, which is given to an author, wherein he could utilize this right for the purpose of monetizing it, so that his creativity or invention that he have utilized could be utilized by the inventor or the creator for future development. So that's the reason why this right is to be recognized, and it is to be protected why protection is required. Otherwise it could be misused by anybody for the purpose, and can create lot many issues with regard to it. Now some people call intellectual property rights as a negative right. Now, why it is called always called as a negative? Because it gives a right only to a particular person, which restricts other people from utilizing this as in their innovations or in creation for further developments or something. So that is the reason some criticize this also as a part of a negative rights. That and as you know that intellectual property rights are limitedly given to a particular author or particular creator, so that this is also made available to the public at any point of time for further research development and things are concerned. So this is what in total what is called as an intellectual property rights are concerned. And if you analyze the intellectual property rights, we have various kinds of intellectual property rights. We start from copyright, trademark, or geographical indications, patents, trade secrets, designs, semiconductor integrated circuited layout designs. So many. This is a limit in which we have categorized it into, but it goes further beyond that. Now, if you look into the various rights that I mentioned about, we start with the copyright. And the Copyright Act is actually an act which is um, protected under the in the Indian Copyright Act. Now, what is this copyright? Now, in your slides you might be seeing so many uh, pictures that are there. Now, these pictures will give you an idea about what kind of protection that we are normally looking into. The copyright is the protection to an originally literary, artistic, or dramatic and musical work, cinematographic films, and sound recordings. So it clearly says that this has been given to like a picture, a creator that who has created a picture, or to a musical works, a composer who have done a musical composing, his rights have been protected, or to given to a cinematographer who has captured a particular scene in a particular background, that full protection has been given to them. Or even also gives rise to the paintings that have been done by any particular creator is concerned. So these are the certain rights which are being protected under the Copyright Act. Now, uh, you might have come across many such kinds of people sharing things in mm, the social media, in various blogs and other things with regard to certain pictures which they may find it very suitable. And in such circumstances, do you think that they violate the particular rights are concerned? There's sometimes it's said that if you are utilizing the certain things, like if I give you a very simple example of copyright is concerned. Now, as a student, as a researcher, you are in a classroom, and the teacher in the classroom is trying to give you certain material notes where which you are supposed to read and come. The teacher is asking you and is circulating a photocopy of it. Now, this is a case, or this is an issue uh, wherein if a student raises an issue, like you are raising an issue with the teacher that you are violating the Copyright Act is concerned, because this is somebody who else who have written it in a textbook which the teacher is photocopying and giving to some students over there. Now, a book, as far as the writer or author is concerned, he has the protection over the right. Now, but does it violate the copyright of that particular author? Now, analyzing it in a violation perspective, there is a copyright violation, but there is an exemption available in the Copyright Act, wherein the works which have been used for the research works, or the photocopies of which have been used for the purpose of research, or circulation of the material used for the purpose of study, educational purpose only, for a limited use, wherein no commercial activity is involved. That means the person who is photocopying is not selling that same thing to a third person, or he's not making mass photocopy of it and then selling it to many people. Therein, the copyright violation doesn't come in, because it is only for the purpose. The moment the commercial angle comes in over, suppose now when you go across the Mumbai streets, you may see so many sellers selling the same original copyrighted material for 150 rupees, 200 rupees, which is, whereas the book costing would have been for 600 or 700 rupees. So therein the angle of copyright violation comes in. The duplicate copy of the same book being sold by a different a copyright violator. Now, when you analyze the copyright, it is an exclusive right of the owner which prevents unlawful use of their work. The term itself very clearly says that it is a right given to exclusive rights given to the copyright owner. Now, the term, that means the copyright owner gets the authorship of this right for how many years? It's just life of the author, and plus another 60 years. That means if the author lives for 100 years, then the author gets it for 100 plus 60 years. That means 160 years. Now, 160 years, the author gets the exclusive right of the work, and nobody should violate such a right and misuse such a right, wherein the misuse or violates such a right which prevents in enjoyment of the rights being transferred to that author of the copyright is concerned. Now, can a copyright be can a copyright be used, or and can there be a copyright for ideas? It protects The copyright can be protected for ideas only if it is in the form of it's in a material form. That means you have to make sure that you have published that in somewhere wherein the idea is being circulated, wherein it could be protected. Now, these are the various kinds of rights associated with for copyrights are concerned: publication, translation, adaptation, broadcasting, performance rights, etc. Now, performance rights is one of the biggest another challengeable area, wherein a comedian who says a comment say or who says a comedy in a stage program, does he own the right over it? This is a one big question. Now, if the comedian says the comedy which he has created using his own ideas are concerned, if it's a scripted play is concerned, therein yes, he can get the rights over it. But wherein he's randomly speaking about whatever the comedy that he's making, therein there is no right associated with it. It's only something wherein which is a sponsored kind of a program, probably a stage program, wherein general speeches are concerned, therein no rights are associated with it. Now, there's also something called as the same comedian using the voice of another person for the purpose of getting for the purpose of performing his act is concerned. Therein, a right violation could come in, because if um, suppose the Amitabh Bachchan's voice been utilized by somebody for the purpose of from some dramatical activities or some stage programs, where the Amitabh Bachchan has made sure that it has been protected according to him. In there is actually a violation. That is where the commercial violation comes in with regard to giving an example with regard to a copyright violations are concerned. Now, you know about what is a trademark, and a trademark is something which is associated with a particular product is concerned, with a particular object is concerned, whether it comes to coca-cola bottle, or whether it comes to the Apple phone or any such kind of products, we normally associate that with a particular product is concerned. So that means something which is visible to us, and we recognize that through a visibility identity mark which is there, which is called as a trademark. And the Trademark Act protects the trademark with regard to any rights are concerned. There are certain pictures been given. You know what all these, what is called as the trademarks are concerned. The marks used for the purpose of distinguishing the goods and services of one brand from the other. This is what is normally called as a trademark. Now it includes words. It can be symbols, shapes, combination of colors. You may know that the Coca-Cola comes out with a combination of blue or the red and white color, right? And Sprite comes out a combination of uh, blue and green color. Blue and green color. The If you look into the McDonald's symbol comes out with a combination of white and yellow color with a slogan which is very, very, which is also a part of the trademark. So, like this is the method in which the normal trademark protection happens, and the protection of rights are concerned. Now, as I said, it includes words, symbols, shapes, combination of colors, etc. The trademark now, I there is a question with regard to trademark is concerned. Now, one biggest question with regard to trademark which comes into is that how will you recognize a trademark? See, the trademark before the Trademark Act came in 1999, was the trademark available or not? So that is the question normally is governed with regard to trademark protections are concerned. The There is a case with regard to Burger King. If the Burger King has filed a case, mm, Burger King has filed a case against a company, against a bakery in Pune, which also has the Burger King as their title. And this is actually a local product which the Pune bakery is been utilizing for the purpose of its own trade. So they have filed a case stating that the trademark violation has happened, uh, and their rights have been violated, and the case is going on still in the court. Now, the in the lower court judiciary, the matter was in the favor of the Pune company, but in the higher judiciary, the matter is still pending. So the decision yet to come. So now the Pune bakery has been using it from before, even before the trademark protection of Burger King came in. So the rights associated with that particular company with regard to that locality is concerned is associated with that Pune company is concerned. But Burger King is a very big brand. Burger King being a very big brand, its rights are associated with world over. So there's a conflict now. So what will come out with the decision will need to be looked upon to understand the trademark issues are concerned. Now, there are so many bottles over there. Which is the right one? It's a very difficult and which is also confusing to understand. Now, when if you go to the railway stations, you may get all kinds of distillery water uh, in different names, in different styles, in different colors, and almost everybody. This is what is called an identical mark. Now, even if your company doesn't have a name of distillery, but even if it looks like distillery, or if even the shape of the bottle, which may confuse the public with regard to whether this is original or a duplicate one, is also one of the concern when it comes to the identification of mark is concerned. So if I have a distillery bottle on the norm or not on the same size or same shape, doesn't matter. But still, if the spelling which will mean an uneducated man may not know what is the spelling of distillery. He will only identify with regard to the color, the style of writing, what do you call, the bottle, and the shape associated with that. So in that circumstances, it is a chance that a person may get misleaded by this. So this is also one of the specific example to make you understand how the trademark are identified when it comes to a dispute with regard to that is concerned. You know, but these again, if you can identify the first one, it is what is the logo with regard to that. Then there is something called as Starbucks. We have already heard about it. Now there's a competitor who came out with called as Starbucks coffee, Snickers, Snookers. These are the common brands, misleading brands, or look-alike brands that normally comes in over the market. People who doesn't know to read will may feel that this is the same as what the original brands are concerned. Now, if I this is the comparative analysis to make you understand what is the basics one and what is the duplicate one. This is how the cheating or the misleading the public with regard to use of brands are concerned. Now, people who doesn't know will always go into this. Now, Sada Bugs case is very famous case because the court has given an order to change the logo, which previously it used to have. I mean, to a new logo wherein it doesn't resemble the same as that of a Starbucks coffee. Now, geographical indications is also very one of the very important, vital rights, right, which has to be protected. Now, why I said geographical indication? This is something which is which is associated to a particular place is concerned. Now, the the geographical indications rights are actually associated with the particular places are concerned. That means it originates from a specific place where a particular quality, reputation, or characteristic of a product is essentially uh, created because of that particular locality. I mean, if I say if it could be the sand, it could be the atmosphere, it could be the product that comes from that particular area is concerned. GAs are used to protect the names of the products that are tied to a specific region and to ensure that the products genuinely or originally belonging to that particular region. So now, it could be possible that if I give a good example of GI is a Kolhapuri chappal, which is concerned. Now, Kolhapuri chappal can be made somewhere else also, but the basic concept of what is been tried to protect over there under the GI is that the use of a particular methodology for the production of that particular product is concerned, it should be associated with that particular area only. Now, if it is made outside, you cannot say it's a Kolhapuri chappal. It could be some other chappals. The product which is made within the Kolhapuri or from that particular region or from the traditional methodology that they use will be branded as a Kolhapuri chappal. That is the way in which the GI protections happens. The conditions that the GI geographic indication protection requires is a geographic origin. That means the product must originate from a specific location, which can be a country, region, or a locality, and the product's quality, reputation, or other things are inherent to that particular place is concerned. And as I said, climate could be a condition, or a human factor could be a condition. Now, mm, Kanchipuram saris, which we normally discuss about all the time, is specifically been woven in that particular locality by a sect of people who are from that particular place. So that's something which is a traditionally woven, um, what do you call, the idea which has been transferred from a generation to generation, which has been utilized by these people for the purpose of utilizing it. There are so many examples that we can give for GI is concerned. Even if we look at the uh, Darjeeling teas are there. The examples with regard to the Aramula Kannadi, we call it in Kerala. This comes from specifically from a particular region in Alapura, or the champagne which comes from France. So the reason why the GA protections are mainly region given is to protect that community which is making this such kind of a product which are um, culturally associated with that particular region, with that region or geography is concerned. So giving them some economic value so that the tradition has been transferred to the next propriety that comes up next generation that comes out, and the proprietary continues to follow that particular production of that uh, product is concerned. Then we also have something called as uh, the GI is totally related to and protected by the regulations under the government schemes are concerned, which is governed by the Geographical Indication Goods Registration Act is concerned, and the term of the GI is for 10 years. That is, the protection is with the particular product protection is only given for 10 years. Thereafter, that can be so new versions, new things coming over. And if you look into the India's GI register, there are more than things have been protected under the GI registrations are concerned. Now, the next part of the patents is IP is concerned is the patent. Now, this is something very, very, very important, and you might have seen in the newspaper recently that India is developing, or India is coming out to be a major uh, player in terms of protection of patents are concerned. Every year, we are trying to protect more and more. Every year, we are trying to come out with new inventions and innovations in the technological in many fields, so that more protection with regard to patents have been given, so that there is a use of these patents for the purpose of development of the economy is concerned. Now, the patents are covered under the Patents Act of 1970. Now, this 1970 Act changed many a times because of the new amendments or new changes, because of the changes in the international arena is concerned. Because the rights of patent, or rights governing the patents, or rights governing the copyright or trademark, everything are actually uh, applicable not just in one particular country. It is applicable to, I mean, it is something which covers many regions or worldwide countries are concerned. So there's somebody who has raised. Is there a question there? Someone, if you have something, please, if you can type on the chat, I will be able to answer those queries. Okay. Now, the Patents Act has been majorly have made the major changes on the patent acts have happened after 2005 TRIPS agreements, wherein we have included many aspects which globally are recognized as a part of the patent. Now, as I said, patent is not just limited to a particular country, which it can be. It has no boundaries, if I say very frankly, because a company which is spending money on uh, inventions and innovations will definitely would like to market it throughout the countries are concerned. Almost every area is concerned. So the purpose of protecting the rights are concerned. So on the basis of for protecting the rights of many people, sorry, for protecting the rights and to commercialize is more. In every country they go for a patent registration. That's the reason why the compliance have been made according to TRIPS agreement, and changes have been made according to that. Now, the key aspects or key requirements with regard to the patent is concerned, we call it as patentable invention. That means an invention or a creation that has been done by the particular inventor is concerned. It has to have certain requirements. The first and foremost important requirement, it should be novel. It means the invention must be new and should not have been disclosed to public anywhere in the world before filing of the patent application. That means the statement is very clear in mentioning that this should be something new. Novelty means new. That's a very simple term to clear it out. What the novelty? I mean, what is this patent is? Then, so it should not only be new. The second important requirement comes in over that inventive step. That the invention should involve an inventive step that is not obvious to someone skilled in their learning. That means, if I suppose wants to make a mobile phone, a normal mobile phone, which nowadays is available easily. We can go and Google it out, get the materials required, and we can make a mobile phone. Now, to make a complicated Apple phone, a normal mobile phone maker will not be able to make it. Why? Because there is some very skilled work that is being involved in it, and and uh, if we give a design of the skill of the same Apple phone to that particular skilled worker, he should also be able to make it. These are two important requirements over there. That means the invention step should involve an invent new technological advanced step, something which is required over there. And next one is the same should be may be made app means sorry the same should be easily be made by a person who is skilled in the same technology, that we call it as industrial applicability. So this three requirement is very important with regard to the concept of patentable inventions are concerned. So I'll repeat, patentable inventions is first one is novelty, second one is inventive step, and third one is industrial applicability. Now, what doesn't cover within the patent? Before I go into designs, I'll just give you a clarity in what cannot be or what will not cover within the purview of patents are concerned. That is, the first one is that it should not be against something which is an already in existence. In a sense, we know that mixing two chemicals, a third chemical name will come out. So that cannot be considered to be as a patent, and patents are not being given for medical, surgical, treatment of humans or animal. All those innovations are never protected under the patents are concerned. And also, the for the purpose of agriculture, methods of agriculture or horticulture, these things are also never covered within the purview of patents are concerned. So this is the legislation which looks into or being used for the purpose of commercialization of your products are concerned. Right. Now the duration. Now the patent is um, normally given for a particular period of time. That means 20 years from the date of filing of application. Now there is a long process involved in filing of patent applications are concerned. When it comes to first testing of the product is concerned, the whether the same product has been or somebody has registered already almost on the similar lines of any things with regard to the inventions are concerned, or the verification of the inventions are concerned, the testing of the product is concerned, everything has been done. And after doing the same thing from the date of filing of the application, 20 years is what the free time that the inventor gets for the purpose of these particular products, particular invention or the product is concerned. Anything which he has invented or anything which he has created is concerned. So this 20 years is his exclusive right. That means in this period he can even sell the product by himself, or he can even give license to somebody for the purpose of um, commercializing his product or invention is concerned. And thereafter, once the license period is over, the product is made available easily open on the market until and unless the patent owner gets some addition. Suppose he modifies it. Suppose I make a cycle. I'll give you a simple example. I make a bicycle. Now the bicycle which has been invented by me is as a right, I'll get it for 20 years. Now in the same bicycle, if I add gears and make it run on the basis of certain electrical some form of an electrical speed or something like that, wherein I put in over there and it runs over, so I am actually modifying my patent further. So again I will get for the newly made product, newly made invention, I'll again get the license for another 20 years. So it can only continue if I go on inventing, or I go on inventing something new on the same product is concerned. So that is the rights which have been given to us. But as far as the rights with regard to patents are concerned, even if it's available for 20 years, you may have to every year do the application for renewing the license are concerned. That is very important requirement with regard to patents are concerned. Now, in the patent, there is something called as um, compulsory licensing is there, which is also one of the very important area which you need looked into. I've mentioned the slide, but yes, I'll give a brief about what is this compulsory license is concerned. In certain circumstances, the government can grant a compulsory license to a third party to use a particular patent invention without the consent of the patent. Now, which is normally done in the cases of public health or to prevent abuse of patent rights. And now, certain drugs which are very life saving, Now, those drugs which are life-saving and wherein, what do you call, there is a need for that the same drug to be made available on a cheaper version. We call it as a generic medicine that we have now in our Indian concept or Indian system is concerned. This is something as an example which you can utilize for the purpose of compulsory licensing as concerned. Then, if there is a patent infringement, now what happens if the patent infringement happens? Now, when the patent infringement happens, the owner of the patent can go to the court for the purpose of getting compensated for, we call it as the remedies, as compensation for the loss that he has sustained. If he can prove that there has been loss because of such kind of violation that he has done, and even he can come out with an stop order from to the other person who is actually infringing his rights are concerned. So this is the rights which are being given under the patent acts is concerned. Mm, Now, there is also something which need to be looked upon is the use of artificial intelligence in for the purpose of creations, technological advancements, everything which is coming over and taking over nowadays is also one of the criteria or one of the probably the reasons why there's a lot many patents are coming over. We are trying to involve into every small aspect the concept of artificial intelligence into it. Now, if I give you a simple example of the use of AI for the purpose, the use of AI for the purpose of uh, recognizing the face ID of people while entering into the office, or use of AI for the purpose during the COVID period of time. The airports, the major offices all had something called as a AI based thermometer, which could recognize a person whether he has a particular degree of whether he suffers from some illness or something like that. This is something which again comes into the reason why the patent uh, protection of intellectual property is more, the protection of patent is more active in in Indian concept or in Indian arena is concerned. And the government is also focusing on the efficiency of the only one major drawback with regard to the Indian concept of the patent is the delay in granting the patents. And so now the technological advancements happens very fast. So in that same pace, the patent application doesn't move. It moves on a very small or slow based, slow mode, if I can call. So this is one of the reason why uh, many of the patents which people are making or registering is not commercialized. So commercialization of patent is one requirement for recognizing the patents are concerned, which is not happening within the country. So government is trying to look into various aspects to come out with commercialization. Even they have also given up lot many opportunities to startups who comes out with patent registration to exempt them from paying lot many taxes, and even helping education institutions to register for patent and exempting the patent registration fees and other things to promote more kind of a patents being filed before the patent officer, so that more advancements in technology or more commercialization of the inventions, the concept of make in India, made in India could be looked into. And there's a department of promotion on industry and international, so internal trade under the Ministry of Commerce and Industry, which is actually strongly working on developing the patent and helping out researchers and students on academics to more work on the patent law and develop more work on the inventions and develop the patent rights are concerned. So this why I said, because Ministry of Commerce and Industry is actually helping out researchers and education institutions to more to develop more innovations in the area of even whether it is science, technology, or pharmaceutical industries, or even in the field of education sector, anywhere it's a concern. If a patent is available, you can definitely look into going for a protection of the patents are concerned. Now, designs is something which is also one very important rights in India is concerned. Now, why I said designs, industrial designs is something which is important for any particular, what do you call, product that they come out with. Now, if you look into the costliest automobile industries which are concerned, if you look into Rolls Royce as an example, now it is not possible for everyone to have a Rolls Royce, right? The design of a Rolls Royce is being designed in such a manner that it has so much of innovations inside. If I look into Rolls Royce, can give an example of patent. I can give an example of designs. You can give an example of many things which has been involved into and looked into privately and very nuancedly and created into a very structured, uh, costliest product, wherein rights of many people are been protected within that particular Rolls Royce cars is concerned. Now, designs are also another intellectual property which is protected under the Designs Act, and in India it governs the designs rules are also there, which it also governs the aspects of the designs protection. Now, what can be protected under the Designs Act? No, shapes, configurations, patterns, ornament or composition of lines or colors in 2 or 3D form the from which the appeals to are solely judged by the eye. That means if you look at the Apple iPhone, or if you look at the Samsung phone, or if you look at the Oppo phone, all the phones have a different design. Now, the reason for different design is because it is everybody's design is protected. Nobody can make the same things are concerned. Now, you may ask me a question, sir, then why in China the Apple like phones have been protected? The China is the only country wherein the applicability of the intellectual property is a very weak. So we cannot, and that's the reason probably they come out with most of the duplicate, or we say that no, China products are very easily available in the market. Now, what can be registered under the Designs Act? Now, designs must be new or original and not previously which has been used in any country before the date of application. That means if I'm trying to protect a particular design of a automobile, suppose the Maruti car comes out with a new design, so it should be something very new which has not been already been protected earlier, and it should be related to the shape. It can be pattern, or it can be ornamental, or so ornamentation of a particular article's concept. Now, this design should be applied to by an industrial process and using any method. It can be manually or mechanically or even by chemical. Now, there is one such kind of an issue that comes out with regard to any designs are concerned. This is something which has recently arisen because of the invent of artificial intelligence concern. Because can a design which has been made by artificial intelligence, use of an artificial, can it be protected? This is one question which is debated right now and which has been happening world over, and discussions are going on. So no clear cut idea or agenda or rule is there, but some countries have recognized it, but some are still on a debate whether to go for it. Now, uh, the initial period for the purpose of protection of any designs are concerned is 10 years from the date of registration. So this period of can be further extended for 5 more years by making by giving an extension application by to the protection of the particular designs concerned for maximum of 15 years. That means you can get 10 plus 5 years of rights as a recognition of a rights are concerned. So that is the way in which the designs could be protected. Now, the this also has a this also comes out, as I said, it's a right, it's a recognition. So that means a rights also comes with, if there is any violation, there is a remedy available. If somebody violates your designs, you can go to the court. The court will either order for loss sustained to you, or even can punish the person. Stop the person from further creating such kind of designs are concerned. And this is also a registration is there, which you have to register with it under the act, and then you get a certificate of the design with regard to that particular design that has been concerned. Now, the reason why the design protection is given is because it encourages creativity and innovation by ensuring creators and business can benefit from the investment in the new and original designs are concerned. And it also helps in maintaining a competitive market. as unique designs gets more consumer choice. Now, if you remember, the over a period of year, the Maruti car has changed from this basic design to a new advanced versions of designs are concerned, and because of which the attraction towards a local car or a cheaper version of the various designed cars are concerned, that has been looked upon, and people are going for a choice of it. So that that competitiveness is improves the protection of designs are concerned, and protecting designs will also help use of unauthorized copying of the same kind of designs are concerned. Right, so this is with regard to the designs acts are concerned, which is also part of the intellectual property rights are concerned. Now, before I go to the next part, semiconductor and integrated circuit layouts. Uh, if I'll just take a small 2 minutes break, because I've been speaking for continuously 1 hour. I just wanted to clear. If anybody has any doubts or any clarifications are there, you can just put it in the chat so that I can address those kinds of an issue if there is any. And I also request Nidhi ma'am to yes, ma'am, if there is any
Yes.
clarification, anything, because I've been continuously speaking. I don't know whether my audience are there.
Ye- Yes, sir. Actually, there is one clarification by Riddhi Chaudhary, and her question is on AI topic. So she's asking, according to you, how can we protect personality rights from deep fake AI?
The Riddhi, the rights with regard to protection of AI is concerned, it's still a question mark, because um, I don't know how this is going to change in the futures to come in, because this is still a debatable. I mean, it can change according to person, because I mean, why I said, because this is something which is concerning a question wherein uh, you are trying to take away somebody else's right through a creation which you are creating. So, wherein you are actually violating the rights of the person is concerned. Now, how, the person who has made the AI for the purpose of such kind of violation definitely will need to be comments, need to be stopped from doing such kind of an activity, because you cannot. I mean, you cannot take away somebody else's personality rights are concerned.
So one more question is there by Kasib Faridi. How can researchers and academic staff balance the need for open access to research findings with the protection of intellectual property rights?
Open access to research findings. Now, as I said in the earlier itself, when it comes to research and developments, most of the IP protections are, I mean, the amendment to the IP acts, like even if it's trademarks or sorry, even copyright or for further higher research are concerned, it is normally been provided if further research or developments are R&D sections are going on that. If I give you a simple example, um, we had something called as an X-ray machine, which used to capture, and we used to get a film printout of that. But the development of the X-ray machine to a computerized method of understanding what is the X-ray print is concerned, is the development further happened on the field of that. So the research which the machine which used to give us something, a limited thing was concerned, has been further used for developing further research is concerned. So for the purpose of researchers is always open to go for further research concern. There is no what do you call as a infringement, or there is no violation kind of a thing that you may have to address accordingly. It is always open for researchers to go for further research, and that's where I was telling that anybody who has got the right over a particular invention can further get a right over the same invention for another additional patent or uh, clarification to it in a future is concerned.
All right. So, sir,
Open
there are no
access,
further questions
no,
right now.
yeah. The open access is concerned, that's why open access is concerned, until that period of protection with regard to that rights of that particular person is concerned is not expired, you may not be able to get the access of everything is concerned. But as far as assisting a person for the purpose of developing the further research on the same thing is concerned, you can always look into. Now, if you look into the generic medicine, the compulsory licensing part is concerned, wherein the government have a right to provide it for the purpose of under the country's consideration of health, consideration of safety, or when it comes to the government policies are concerned, when the government have the right to, wherein they always have a, but I mean upper hand over the open access concept part is concerned.
So as of now, we don't have any further questions.
Yes. So we go into the next part of it called as semiconductor integrated circuits layout design. So this is another part of IP which uh, this is another part of IP which is also very important. Why I said, because the the semiconductor integrated circuit layout designs is a uh, protection for designs which is safeguarded under the IP Act for the creator to ensure that the innovation in designs are properly protected. Now this is something which is connected with the engineering or the what do you call, the engineering people are concerned, who are properly working with regard to the semiconductor designs are concerned, and which is covered under the Semiconductor Integrated Circuit Layout Designs Act 2000. Now, it provides an exclusive rights to the creator of the original layout designs, preventing unauthorized reproduction, sale, or distribution of the layout designs are concerned. Now, it also has to fall within the certain criteria and categorizations like uh, the layout must be original, it should be from the person's creator's intellectual, and a design must not have been commercially exploited somewhere else, or the layout design itself is protected, not the underlying idea. Now here you have to create the product for the purpose of protecting it, or it should be made available to the person to analyze it and protect it. So that is the criteria given under the Designs Act 2000 for the purpose of protecting anything which is coming within the purview of semiconductor integrated circuit layout designs are concerned. Then again, this goes through a registration process which is done through the IP office, and if there is any infringement, you always have the rights protected under the acts concerned. Now, the reason again for the purpose of protecting the semiconductor integrated circuits are concerned is, I said, innovation, the technological advancement, and this is normally, if I'm not wrong, many of the education institutions have specific labs been created by the ministry for the purpose of developing and protecting semiconductor circuit layout designs are concerned. So there's a lot of government support that comes in from the in any institutions or any education institution who wants to have a support over this. They protect normally. And while in the DPIT, when we were working on, we were being asked to regularly visit out the engineering institutions and other technological institutions for the purpose of promoting people to protect these rights are concerned. So this rights has been strictly protected under this act. Now, next part of the IP is with regard to trade secrets. Now, this I think everybody knows what is a trade secret. Nobody knows what is the recipe of the Maggie or the KFC, and everybody tries to make a different form of Maggie, which always have a competition, and but still Maggie is still the Maggie. And we why the reason which we never call anything as a noodles, we always call it as a Maggie, because that is the brand which has been which has a trade secret. Because of this taste, we are utilized to eat the Maggie's. So now the similar way, as I said, KFC, very versions of KFC have come, but still the secret we doesn't know what is the recipe behind it. Now every industry, every business entity would like to protect the secret from which their business runs on. So trade secrets are a form of IP that protects confidential business information, uh, which has a competitive edge over the other country. Now, the protection with regard to the confidentiality or secret with regard to this particular trade secrets are concerned, it is very confidential. Now, according to the legislation, the trade secrets, the definition of trade secret, which says that is any information, formula, pattern, method, technique, or process. I think it means any information which is in the form of a formula, pattern, method, technique, or process that is not generally known or easily accessible, and that provides a business with an economic advantage over the competitors who do not know to or to use it. So this gives an idea about what the complete concept of the trade secrets are there. Now, the very simple example of trade secret, as I said, is the recipes, wherein you never know what is how the Coca-Cola has been manufactured, or you never know how the KFC masalas come from, where the KFC masala comes. So all these are the trade secrets that they have always been trying to protect it. Now, um, we call that secrecy. We call this because of the secrecy they have an economic value, and for protecting these secrecy for which the benefits comes in, the reasonable steps in the form of trade secret protection is being given under the legal framework. uh, Many, I mean, this trade secret is not just related to one particular country's concern. Many of the countries have the same act wherein they look to protect it. Unlike patent or trademark, it doesn't come within the purview of a particular. Sorry. Unlike trademark or patent, this doesn't come within the purview of a particular period or term for protection. It is as long as the information is confidential, we call this, or else we can call this as long as the business entity would like to protect it. So, trade secrets doesn't require any registration or disclosure to any government authority. It is only helps to maintain the confidentiality of it. And the recipes are very nobody knows about the various which have been already available under the market is concerned. Uh, these are the basics of the rights which I was trying to look upon into various aspects are concerned. One step. Yes. Now it's a comparative chart for you to understand the protection of various IPs are concerned, and the maximum term in which the protections are being given, and the rules and acts which governs these protections are concerned. If you look into the patent, it's for 20 years, and it is a mandatory every year to we go for an application, and this been protected further. For trademark, it's lifelong. That renewal is every 10 years. After every 10 years, you have to go in for renewing of it. Designs is for 15 years. That means 10 plus 5. After 10 years, for next 5 years, we can get it renewed. Copyright for 60 years. Renewal not required. It's automatic. Life of the author plus 60 years. So the renewal is not required. It gets, I mean, it is automatic. Geographic interest is also lifelong. After 10 years, you have to again renew it. This is one chart which I wanted to show you. Next. So probably I was fast, so I could finish off with it in an hour or so. So anything else further you would like to ask? Because to be basically speaking about various aspects of IP is concerned, uh, 1.5 hour is more than enough for us to speak on. Uh, and I did not want to touch upon the other authors, other areas also, because I saw the topics also where in the future of IP, the various legislations are also being looked upon. So repetitions have been avoided. I try to avoid repetition, but still, if anything further clarification required, I can definitely speak about.
So before we move on to the questions, I would really appreciate the fact that every slide was very lucid and the whole presentation was very comprehensive. So, sir, thank you for such an enlightening session. And so there is one question from Mariam Fareed. She is asking that, in your opinion, how the libraries be accustomed to the intellectual property requirements?
See, when you look into the library part of it, as I said, it is for the purpose of education purpose, education and research purpose. There have been always been the exceptions being given to the libraries, wherein we could keep the photocopies of books which are very rare, which are not available in the market. We have the exemption because that is only available. It's not commercially been utilized. So it's only available for the purpose of references and for the education training purpose. See, now if FDP would have been something on an offline mode, there would have been a reading material being circulated to you all. So in the reading material, there would have been lot many articles related to various topics of law or various subjects which have been covered over there. Now this is something wherein you could utilize, and we specifically write it as an educational training purpose only, which exempt us from getting into or getting violating any of the copyrights, or I mean, which gives an exception for us for the escaping these rights are concerned.
Okay, thank you, sir. And one information for our participants that this is a one-way communication. As you know, that this is being telecasted on YouTube, so you can post your questions over in the comment boxes. So, do we have any other questions from the participants?
Before we conclude, let me also take a point of thanking the organizers, the university, the School of Law, Integrated University and School of Law, for organizing such kind of an activity, because mm, looking into various FDPs that are happening all over, we have so many FDPs happening over, but specific subject-wise FDPs happening, where limited FDP which are having subject-wise, which is very important, because everybody would like to understand a subject specific into that particular area is concerned. And I would definitely would have looked into, I mean, probably in the future you should also look into teaching IP law, not just research, to teaching IP law is concerned, wherein we could come out with nuances how to teach the intellectual property right law in the classrooms. What kind of examples could be utilized? What kind of uh, cases could be looked upon for the purpose of teaching the IP law in the classrooms are concerned. When a teacher is trained to teach the same subject who are teaching presently teaching in the, it will also give them an introspective effect to understand, okay, I could change over from this particular methodology to this particular methodology for the purpose of teaching. So that is also one of the area which FDPs could also be looked upon into, wherein to train the future teachers for the purpose of various subjects are concerned. Not just IP, I'm just telling about any of the subjects are concerned, because we fall short of teachers nowadays to get into teachings are concerned. So this is one of an area which I mean, I always suggest all the universities to look into. And I should thank the organizers, especially the ma'am, for giving me an opportunity and the giving me a chance to speak on the topics concerned.
So rather, thank you for being here, for being with us, and for this incredible and valuable knowledge that you have enlightened with us today on IPR. And definitely, we are going to implement all these suggestions and advices that we are getting through this FTP via experts and the participants. So before we are ending this session, there is just one more question by a student, and the question is. So, how can the student benefit from the application of IPR principle into teaching?
Now, when it comes to intellectual property rights are concerning, as a student benefit is that if you are a researcher, I mean, student researcher who is looking into doing some research with regard to intellectual property rights are concerned, can understand the nuances what are associated with the IP is concerned. If you may come to know about what IP level that you need to look into. If you are doing an invention, then you have to go into the patent is concerned. If you're doing making composing a song or making a painting, you have to go to the copyright area is concerned. Or if you're creating something which is associated with designs are there, so you can go into design act is concerned. So it's easy for you to further go into area where you can file the application to get your protections are concerned, or something which you have already researched or you have already developed something which is there in your mind which you want to develop. So you can definitely develop such kind of a thing and get your rights protected under the intellectual property is concerned and commercialize it. Why I said there are so many organizations which are looking into new young ideas and minds, ideas and technological developments which can be commercialized by these people, so you get a chance to do that. So students, I mean, I have some students who are working on, I mean, here in Amit University we have students who work on the education softwares, making more effective education software which can be utilized by the institution itself and which is funded by the institutions. So you can also get a benefit, such kind of a benefits wherein your own startup could be taken up by the by your own institution or some other institutions. So this kinds of benefit will definitely come into when it comes to IPR is concerned. And second thing which I wanted to say is that if you are a law student, you always have a right to you always get a dispute with regard to intellectual property rights are concerned, and you definitely will be able to defend the rights of people whose IP is violated.
Absolutely, sir. You are right that if the students are investing their knowledge of the class into the practical aspects, they will definitely get a clearer picture of what actually IPR is going to benefit them in their real life. So, yeah, and I hope no any questions are there, and those who have actually asked the questions have been satisfied by the sir's very clear commitment towards the answering. So, sir, at the end, I would just like to thank you with all my heart that you have given your time and you have invested so much of your effort. I'm really, really grateful. We're all grateful, and thank you for giving us this exceptional knowledge today.
Thank you so much, ma'am. And as a teacher, it is the right of every teacher to make sure that whatever knowledge we have, we share along with our students. So I'm also for doing the same thing. What as an institution you are also doing, and it's a wonderful experience to be part of this faculty development program. Thank you so much, ma'am. And good day to all,
Thank you
and all
so
the
much.
best to all the students and all the people who are attending the program.
Thank you so much, obliged, sir. Thank you.